Good day to you. It's the 20th of September 2023. I just want to do a little bit on the law of contract here. And this is only very basic. I'm not your lawyer. I'm trying to inform people how it works. I'm not getting any payment from YouTube or anyone else, and I can't be held liable for what judges do or lawyers do or anybody else. And in fact, you could have the law on your side and you could still lose. I can't deal with that, so I'm not taking liability for it. A contract has certain common law ingredients to it that go back hundreds of years and will always be the case. There's a bit of law built around it, but the basic is judge-made law. It's common law. It's never going to change. And here is what they are. The first thing is an invitation to treat. If you're going down the street and you would like to buy a new lawnmower now, you have a few pounds, and you're going to buy the lawnmower now and have it for the garden next year, and you see this lovely lawnmower and it's €100, and you decide we've got to have get the €100 out, and you go down, I'm buying it, I want that. If it's a mistake, if it's not really for €100, that's an invitation to treat. The shopman can say, no, we made a mistake, that's only an invitation to treat. It's only a form of an advertisement. It has no legal basis whatsoever. Okay. The next thing is there has to be an offer. The offer can be made of either side, either the seller or the buyer. There has to be an offer. The next thing that can be is a counter offer, and the counter offer can be somebody who we'd say you go in for the lawnmower, it's €100. Oh no, it's not, it's €1,000. We forgot to put on the note. All right, I'll give you 100 for it. That's an offer. And your man says no, it's 1,000. Well, then we'll not deal. Well, here, I'll tell you what I'll do. I'll give it to you for 950. That's a counter offer. The other party says, well, I'll give you 9. That's a counter offer. So we'd say, your man says, all right, I'll take 9 now, and I'm telling you, I'm not making much on, I'm taking 9. Now you have an offer. The next thing is the acceptance, how it's accepted. Once that offer is accepted, it's subject to certain conditions, it's legally binding, and there's no way out. There is no way out, sorry. Now, folks, as a farmer, I have to have the phone on. I'm sorry about that. So now we have the offer, we have the counter offer, we have the acceptance, and generally speaking, the acceptance is binding. Now there are certain conditions. There has to be the intention to create legal relations. There has to be the intention to create legal relations, and that's from the circumstances of the case. So you go up to buy the lawnmower. I'm taking it at $950. If your man issues the receipt, gives you an invoice and says, there's the thing there, and you then say, I'm buying it, and that's properly proven, then you have a contract. Now, everyone's going to shout, hey, maybe there's nobody there, nobody saw it, oh, nobody seen it, I never seen it. That's to the facts of the case. The judge has to define that and take that out from the facts of what happened. But if it's an offer and acceptance, and it's clearly meant that the man intends to buy it, well, now we'd say that this is a very, very old lady, and he asked her, have you a garden? No. Well, then the possibility she could be raving. So that there has to be the intention to create legal relations. At the same token, if it's a young person, they can contract and enter into contracts where it benefits them, and for basic foodstuffs and things like that. They can say, right, I'm buying a loaf of bread, some butter, and some ham, and they can say, I'll pay you tomorrow. That's binding. But if they say to you, I'm buying a lawnmower and the child's only 14, well, no, and my father will pay for it and all that doesn't really work too well. As a minor, I bought a farm and I had but that's different. I gave me consent that when the money came through from an accident, I had to buy the farm, and when it did, I did buy the farm. That's to my benefit. So if it's to the child's benefit, usually it'll stick. If it's not to the child's benefit, usually it won't. In any event, there has to be the intention to create legal relations, and you have to be careful when you're buying things. If you clearly state you intend to buy it at that. Now, there is things called misrepresentation, mistake, fraud, and all that. Essentially, the buyer must beware. That's a legal rule. The buyer must beware. Must beware. It's up to you to start the tractor, to judge it and do everything. It's not up to the seller. If there's certain things in the mark, you'll see a sign up, all heifers presumed to be maiden unless stated otherwise. That means if the heifer's in calf, you can be caught. That's not what the man bought. And if she dies giving birth to the calf, you can be caught for the whole cost, and that happens, right? So the thing about it is that you have the offer, you have the counter offer, you have the acceptance. The acceptance has to be communicated some way, and it can be by hand. Now, there is no rule that contracts have to be in writing, except it says so in law, and land law is one of those exceptions. Now, you could enter into a contract to buy land at a future date, but if it's done legally, you might be caught. But this thing about I'll buy it, I'll take it, or a fella coming on when land's for sale and one bidding out the other and he takes it, and then he realises he has nothing to pay for it. There's not much you can do in that case because the land is not actually bought until the contract is signed, as a general rule. That's writ-based law. That's the old English law where you have a writ, and there's very few remedies. You can't get an order of injunction or mandamus, or you can't force them to do something, but it just means the thing is transferred. So that's the old law. Now, land law tends to be like that. There's no such thing as a house in law. There's just that the land the house is on. Have you that now? Now, so you have the offer, the exception. Now you have to prove the intention to create legal relations. That's where you're going to need to be careful. And then you have to communicate the acceptance. And if it's insurance on that, and you write the postal rule applies. That was a London house fire company. They were insurance, and your man sent the check off and the acceptance form on a Friday, and it didn't come into the insurance company till Monday. But the house went on fire Sunday morning, and it was proven he had a contract. The postal rule means it's when it's posted, not when it's received. There are exceptions to that will take further study to do. So, but by and large, when it's communicated, I'm taking it, that's it, we're in. Have we a deal? We have. If you say we have a deal, then subject to something, if it's subject to contract, that's essentially weakens the contract. If you say it's subject to plan of permission, it's the doubtful if you have a deal at all. Doubtful. The seller of the land could probably say, I'm not going along with that. I'm just saying, subject to some conditions, or subject to getting a loan. It's weakened it. If you buy a farm subject to getting a loan and some lad buys it on instead, you go to taking a case, you hadn't the money when the thing came up. I'm just saying these are complications. Now, so now just to go through these again, you have an invitation to treat, you have an offer, you have a counter offer, you have an acceptance, you have the intention to create legal relations. You have to communicate the offer to the other party by some means. Okay. Now, how can you get out of it? How can you get out of it? How can you terminate it? How can you terminate it? There was a company during the war in England, I think it was, and they wanted everyone to join the army, and there had a couple of boys working, I don't know, was it a hardware shop or something, and they posted a notice saying that anyone that joined the army would get half their pay while they were away in the army. And one fella took it up and he got guaranteed half the pay, but another lad did the very same. When he went to tell them he was taking the offer, they said, "Oh no, one lad already took it." But he had already joined the army. Now, if he hadn't joined the army, it might be different. But he told them, "I'm taking that offer," and he joined the army and he served the 3 years. And when he came back out, he demanded his money and they wouldn't give it to him. And he won that case. That's Billing versus Arnold. Employees posted a notice offering employees who joined the defence forces during the Second World War half the salary while the military service. When an employee stated that he intended to avail of the offer, he was informed they could not do so because another employee from the same department had already done so and he could not be spared. Despite this, the employee joined the army, and when the war was over, he sued his employers, and they were held liable to pay him the money. So it's not that easy getting out of a contract, whether you're the employer or anybody else, or what it is. You have to you make an earnest in communication that you're taking the offer and paying the earnest. You know the way you pay 20 euros, a luck penny, or you pay 20 euros as a deposit. And that is an indication that you intend to deal. That is that effect. There's no real much effect because even you didn't, it'd depend on the circumstance. But if you put a deposit down, but then you can put the deposit down and you could have subject to some other condition, like plan of permission and everything, and that might nullify the contract. So right, so that's it. Now the other thing I didn't deal with is the consideration, the price, and so to be successful in an action for contract, it must be proven that one party gave or promised to give some advantage to the other. This advantage to the other is known as the consideration, and is the third essential ingredient of a valid contract. Consideration was once judicially defined as other either some right, interest, profit, or benefit accruing to one party from some forbearance, detriment, loss, or responsibility given, suffered by the other. You have to give something for it, right? Okay. Now there's a sort of a principle that the consideration, that what's paid or what's given for the property or the cow or the car or the lawnmower, has to be adequate but not sufficient. In other words, the courts don't want to get involved in what the lawnmower's worth. You got an offer, the man said it was 800, 900, and you agreed on 900, that's it. Whether it's adequate or not has nothing to do with it. You might get it for a bargain, and the courts won't intervene. But you have to have some wee strain. It's been said that a 12,000 euro car that is sold for €2 and everyone knows what they're doing, the courts will not intervene. Now, with father son and father daughter, and mother daughter, you often get this sold on for natural love or affection. There has to be something in exchange, because otherwise, giving a thing away would be a contract. You can't have a situation where a charitable organisation goes round and gives somebody bread to keep them alive, or give them soup at night, and then that person can sue when they don't come the next night. You can't have that. There has to be some consideration to make the contract enforceable, and the consideration, there has to be something, but it doesn't have to be sufficient. It just has to be something adequate. Possibly now, buying a good detached house for €10 would not probably work. I'd say the courts would say that. How can there be an intention to create legal relations? I mean, the person selling would be going a bit mad. There might be something wrong there. Is there something amiss? But if it was for 5,000, even though it's worth 500,000, once it strains the person a bit and the person has to go pooching through the pockets and see where it is, then that's all right. So there has to be a consideration. It doesn't have to be a lot, and it certainly doesn't have to be the value. The courts don't want getting into that area. That's for the buyer and seller to be aware about. There's things to do with minors. There's things to do when you can get out of these. There's estoppel. There's a whole lot of things. I have to wind up this now for the time. We'll just go back on it again. You don't have to have a written contract unless that can be. You can have a written contract. If you had a written contract, you couldn't buy the newspaper in the shop because you need a solicitor with you. For land, you do need a written contract. You do need a written contract. And it's not really signed unless there's a special contract to buy the land. There's an ordinary case, a person who bids on a farm to an auctioneer, it can walk away and leave it there. Now, so an offer, a counter offer, an acceptance. So to give it simply, an offer, an acceptance, the intention to create legal relations, there has to be a consideration which has to be adequate but not sufficient. And so offer, acceptance, intention to create legal relations, and the offer has to be accepted. It has to be communicated. There has to be a way agreed to communicate it. In the hardware shop, you just sign your name on the invoice. That's it. You're caught. You bring the stuff away. You're caught. You have to pay for it. You have an account there, and you have to pay for it. You agreed. So that's to show you're in earnest. That they're not just giving it to you, or you can't say, I thought they were giving it to you for nothing, and all this. So now, do you understand the basics there? I've gone very basic on this, and I again emphasize this is just for guidance, how the law works. There's the Sale of Goods and Supply of Services Act, which states that goods have to be of a certain quality and to tidy it up, because under the old common law, it was buyer beware. There was very little obligation on the person selling to explain what the thing is. The old car might have a rotten gearbox in it, and if you didn't check it and give it a rev and check it around, you could be caught out. But at the same time, the courts don't want to get into whether you told them about the brake was slipping or there was a bit of a clutch slip there. That's up to you. It's up to you to test it and to look about buyer beware. And then the Sale of Goods and Services Act comes in to protect you for certain items. And there's a whole lot of law about the cars and selling cars and all that. That's the law of the Oireachtas, the Dáil and the English parliaments and that coming in to tidy up areas of this. I'm merely here giving you the basic law of contract under common law of Ireland. Hopefully that's some good. An offer, an acceptance, a consideration, the intention to create legal relations, and the acceptance of the offer. And if it's accepted by post, then normally it's valid from the minute the letter is posted in the post office. There are ways of getting out of it. Minors are not as strongly bound. If they buy something that's essential for them and that they need, then they are bound. They could have money later on, you could sue them for it. But if it's something that's not to their benefit and somebody takes advantage of a kid or a child, then that weakens the contract quite a lot. There's duress. You can't put a weapon over a person or threaten to shoot them if they don't sign. That's not binding at all. And common sense things like that do apply. So this thing about some fella sold the pub, sold his farm, or sold his property in the pub when he was drunk, that is baloney. That's nonsense, because he'd have to go in the following day and sign the contract, and he didn't do that. That's all nonsense. But it doesn't have to be in writing. It can be any form, unless it's certain things that are in writing, and land is probably one of the few I can think of. That's it, folks. A thumbs up or a thumbs down. I did waffle a bit there, but it's not easy, and I had a phone call because of something on the farm. So I hope that's a help to you now, just the basic law of contract.